afternoon, ladies and gentlemen. This is our third webinar for today. I hope you still have capacity to take in more because this is the third session. So we have Khoo, Mr. Eric Khoo with us today. He's the Deputy Director for Global Engagement and Business Development from IPOS International. He heads the Intellectual Property Office in Singapore and oversees the expansion of IPOS International into key global markets, providing advisory and solutions to private enterprises and governments on intellectual property creation, commercialization, and management. So I don't want to take up too much of Eric's time because we're very time strapped today. I'll pass the stage over to him so that he can share with us more on today's topic, which is understanding types of intellectual property and how they differentiate businesses from others. Eric, the stage is yours.
Thanks so much, Macy, for the kind introduction. Just to check, can you hear me clearly?
Yes, we can hear you well.
Okay, wonderful. Okay, so let me just pull up my slides. Give me a second over here. Okay, and just to check, you can see my slides properly?
Yes, we are seeing the speaker's view, so you may want to go into your display settings and swap the presenter view to...
Okay. Okay, how about this now?
Yes, all good. Thank you.
Okay. All right, so very good afternoon, everyone. So as Macy has kindly introduced, my name is Eric and I head the global engagement for IPOS International. And my topic today is going to be on understanding the types of IP and how they actually differentiate a business from others. So just to give you a very quick introduction about who IPOS and IPOS International is, right? So IPOS really is the government agency under Ministry of Law. And it's the agency, if you want to register for a trademark or patent or registered designs, that's the agency that you actually go to. So for myself, I actually come from IPOS International, which is a wholly owned subsidiary of IPOS. So we are the expertise and enterprise engagement arm of IPOS. And under IPOS International, we actually have about 100 IP experts under one roof. So the next slide, I'm going to introduce you to a bit of what IPOS International actually does. So there's maybe three, I would say, major business segments that we're actually in. Number one is actually on the left side, which talks about us providing consultancy services, particularly for businesses to understand what kind of IP and IA holdings that they actually have. So that's the consultancy business. And in the middle portion, we have also a service which is called patent search and analysis. So essentially, we actually provide patent search and analysis for companies that are looking to understand what kind of research trends are out there and what companies are actually putting money into different areas of research out there. And finally, on the rightmost side, you will actually see that we do also provide IP education training. So we offer courses, anything from as short as a half-day session until anything that's as long as a 2-year part-time master's program that we actually have together with the Singapore University of Social Sciences. So that's just a very quick overview about who IPOS and IPOS International are. So I'm going to talk about today's topic by starting with, an understanding about what are actually intangible assets. So to give you a context about what intangible assets, we need to first differentiate between what are tangible and intangible assets. So tangible assets, as you can see on the left, are things which are, as the name suggests, right, tangible. So you can touch, see, feel. So things like cash, land, equipment, inventory, machinery, and so on. Whereas intangible assets tends to be things which are you can't really touch and feel. So this will be like your patents, your trademarks, your copyrights, your customer list, your employment contracts, and so on. So another couple of key differences between tangible and intangible assets is that tangible assets can be destroyed by a physical event, such as fire or flood or earthquake, right? So things like your machinery, everything will be destroyed in that. Whereas intangible assets cannot be really destroyed in a sense by a physical event. Another very key differentiation between tangible and intangible assets is the fact that for tangible assets, they tend to be able to be only used or utilized by a single party at any point of time. So let's think of the example of land. So if you have a piece of land and you actually build a factory over there, your factory can be producing for you at one point of time, or you can actually allow this factory to be rented to another person. But at any point of time, right, there's only one entity that can actually use it. Whereas in intangible assets, you can actually license it to many different parties. So like, for example, a single patent, I can license this patent to a party in, maybe making a product out of it. I can actually license to another party with different restrictions. So a single intangible asset can actually be licensed to many different parties at the same point of time. So that's a very powerful concept about intangible assets, which is you can have this multiplier effect on its use. So those are a few very key differentiations between tangible and intangible assets. Okay, so now we go a bit deeper into the types of intangible assets. So you see at the top bar, we have a subset of intangible assets, which is called patents, trademarks, designs, copyright, and trade secrets. And I'll go into a bit more details into each one of them as well. So if you take a look at patents and trademarks and designs, right? These are 3 kinds of IP assets that you actually need to register in order to get a protection for it. Okay, so register as in you need to actually file for a registration with a local patent or trademark office. Whereas copyright and trade secrets, you don't actually need to register them. So there's no requirement to register. Now, so what actually is a patent? So a patent is basically an exclusive right that's granted for an invention, so which is a product or a process that provides in general a way of doing something new. So a patent really is something that protects your idea of doing something new, okay? Whereas a trademark is a sign that's capable of distinguishing the goods or services of one company from the other. So McDonald's, for example, you ask any kid, they look at the golden nachos, they'll know that this actually represents McDonald's. Okay. And finally, for industrial design, it actually is protecting what we call the aesthetic aspects of an article. So how your product actually looks, it has nothing to do with the functionality. So example, if you think about the iPhone, right? Before the iPhone actually came out, all phone designs, you look at it, whether it's from Samsung or any other companies, right, tends to have a screen at the top and kind of like a touch button keypad at the bottom. So when iPhone came out, it was a revolutionary new thing that nobody has seen, just a single glass piece on the top and the keyboard is integrated into a display itself. So that design has become very iconic and everybody knows that, the iPhone design, how it actually looks like. So if you move into copyrights, you're now talking about rights that creators have over their literary and artistic works. So under copyright, there's a lot of different things that fall under that. So it can range from books to music to paintings, sculptures, films, computer programs, and so on and so forth. And copyright, actually, there's no requirement to register it. And I'll talk about this a bit later as well. And finally, for trade secrets, so everybody knows that, for Coca-Cola, till to date, nobody really knows what are the constituents or the ingredients that goes into a Coke formulation. So a trade secret is something that you actually keep dear to yourself and is not easily divulged to other people. So now we've talked about IP assets and some of them that need to be registered, some of them don't need to be. And under intangible assets is actually a much larger group, which we call, for example, know-how. So if you think about McKinsey & Company, which is a very big consulting firm, the know-how actually resides with its individual consultants because they have the experience in working in certain industries. So the know-how is actually in the people itself. And then if you move next to, systems and processes. So GE is a huge company that actually does a lot of, process improvements and how to actually build a plant processing machinery for other companies. So they're very good in the systems and processes. And if you take a look at Pfizer, for example, drug companies particularly, regulatory approvals are something that's very important to them. Without that, they can't actually start to market or actually sell the drugs. And then you have domain names and data, which is important for Google. So these are a larger group of intangible assets that you may know about them, but actually don't actively think of them as part of intangible assets. So just wanted to highlight this couple of things over here for you. So now if you were to now look at the different types of IP, right? So this chart kind of like summarizes to you what are the types of IP, what's the ease of production, the duration, the scope, and the cost, right? So from the top with copyright down to the bottom at patents, right? The easiest, arguably, to get a protection for is actually copyright. Why do we say so? It's because as long as you have reduced it to form or you have actually performed it, your copyright actually starts from there. right? So there's no need to actually go to register. So as long as you reduce it to form, as in you have put it down in writing, you have on your computer a copy of your source code, for example, or that you have actually done a performance, the copyright actually starts from there. And the duration is actually life plus 70 years of the author. So it's one of the longest durations you can actually have for IP protection. And the cost is probably quite negligible to it. So if you move down to the different types of IP, you'll see that actually patent is going to be the most difficult, simply because you need to have a patent document that actually needs to be filed with the patent registry, and it has to be written in a certain manner or way. So patent registrations tend to be the hardest. Duration is about 20 years. Scope of technology is, scope of protection is usually on technology, and the cost is actually on the higher side. And again, I'll talk about this later on in my slides as well. Right, so just to give you a very quick overview about the different types of IP, their ease of protection, and of course the costs associated with them. So now that we have a basic understanding of the different kinds of intangible assets, right, you just have to remember this thing, which is don't think of them as separate items. In fact, they can actually all work holistically in one single product. So what you see on the screen right now is actually a Nespresso machine. But if you look at this espresso machine, right, within its one single product, you have so many different kinds of IP that's actually protecting it. So if you take a look at, for example, the logo of the Nespresso machine, that's actually protected by trademark. If you look at the milk frother, which is that black little canister where you pour milk in and it produces the froth for your cappuccino or latte, right? That particular milk frother is actually protected by a registered design. So how it actually looks. And then down to the machine itself, right? How do you extract the coffee from a capsule? That's actually protected by a patent. And then of course you have your marketing brochures, which are basically protected by copyright. And then the blend of the ingredients within the capsule itself, how much coffee powder goes in, what percentage of it is Arabica versus what percentage of it is actually Robusta, and so on and so forth. That's actually a trade secret, the formulation itself, and so on and so forth. So you see within a single product, you have so many different kinds of intangible assets that's actually covering it. Now, we talk about how valuable IP is actually to a business, but can we actually put a value to what the IP contributes to a particular product? So I cannot give you exact numbers, but maybe these examples will actually give you some idea. Okay, so if I show you this diagram on the left here, it probably doesn't actually mean anything. So this is actually extracted from a patent document. But if you give it a bit more, which is the title of this patent, it says method for a node ranking in a linked database. Probably still doesn't tell you too much. But if I tell you, this patent is actually by Google, I think now you can understand a bit more about what this patent is about. Now, this is in fact Google's famous page rank patent. And this actually talks about how to value a web page based on how many pages are linked to it. So this was actually filed back in 1998, and the approach actually provided a very significant improvement in the quality of search results. So if you think about back in the days, the competition between search engines, there was Yahoo, Ask Jeeves, and then there's Google and so on and so forth, right? Google really stood out because the search algorithm came back with very relevant results. And this was a pattern that's basically underlying the whole of the Google's algorithm. Interestingly, this original assignee of this patent was actually Stanford University, because at the point of time, Google's founders were actually both studying at Stanford, and they were actually using Stanford's resources to actually come up with this particular invention. So in return of licensing this particular patent over here, Google exchanged 1.8 million of their shares with Stanford. So as of November 17, I just checked about earlier this morning, right? Google, or Alphabet Inc., which is the parent company of Google, the stock price was at $1,000, sorry, 1,760 US dollars. So 1,760 US dollars for one stock. So now you multiply that by 1.8 million shares. You can roughly understand what value this particular patent actually has. Okay, so that's kind of like one aspect of looking at how a patent can actually be very, very important to a company's bottom line or revenue. So let's take a look at trademarks. So see on the screen right now, there's two different products over there, or rather I should say the same product. It's just that it's a different brand. So on the left, you have Advil, which is actually an anti-inflammatory drug. And this particular Advil is owned by Pfizer. And on the right, you have this similar looking packaging, which is the brand is called Exact, and ibuprofen is actually the active ingredient. So ibuprofen is actually the anti-inflammatory drug, and the same component ibuprofen can be found in Advil as well as this one on the right. But you look at the difference in prices. Advil sells for $12.96, whereas for ibuprofen, it actually sells for $9.99. So there's actually a very huge difference in pricing, about 23%. And you might be thinking, oh, maybe because it's Advil that's actually the one, or Pfizer that's the one that actually came up with the drug, but it's not. It was actually developed by Boots UK back in the 1960s. And interestingly, because it was in the 1960s, the patent has actually expired back in 1984. So first of all, Pfizer was not the one that actually came up with the formulation. It was actually Boots UK. And the patent has expired. And yet people are still willing to pay a premium to buy Advil over this Exact brand ibuprofen, even though the constituents inside it are exactly the same. So you're paying a 23%, probably just because that it's actually produced by a company which is more well-known, Pfizer. So to give you another example, so the bleach that you see on the screen right now, the budget bleach, that's the NTUC house brand. And then on the right side, what you see is actually by a more, I guess, multi-international brand, Clorox. And again, inside them, they have the same kind of a key ingredient, which is sodium hypochlorite. So if you distill it down to, how much do you pay per liter? It's 62 cents per liter for the NTUC, and it's almost double that, 125 per liter for the Clorox. Now, it's essentially the same thing. So why are you paying so much more for Clorox rather than NTUC? Probably it's because of brand perception, and it's a brand that you might trust to be better. So really the trademark itself, right, when it's slapped on the same thing, it can actually double or increase your selling price a fair bit. Right, so now let's take a look at the value attributable to registered designs. Some of this might be familiar to you, some of this maybe not. So if you look at the chair on the top left corner, right, that's actually a lounge chair that was actually designed by Charles Eames. I think it's become quite iconic, and even though this was actually, the registered design was actually filed in 1949. So we're talking about a 70-year-old design, which till today still looks very classic. So that's actually a very iconic design lounge chair by Charles Eames. If you look at the motorbike, it's actually Model W by Harley Davidson. And of course, I think all of you recognize the iPhone in the top right corner. And the bottom left corner, I wish I was sitting on one, but I'm not. So that's actually the Herman Miller Aeron chair, iconic design, and costs a few $1,000s for each chair. And you have a Fender guitar, and finally, of course, the Lego Man. So this designs itself, one look, you immediately will know or associate who is the manufacturer for them. So because of this very iconic designs, again, a lot of these products are actually selling for much, much more money than a comparable design from another brand might be. Okay, so when we are taking a look at this collectively, so if you now combine your patents and trademarks, and of course also your registered design, so all your IP collectively, right? And we can actually see this very strongly in the smartphone industry. So between the different phone brands from, the Huawei P9 to the Samsung Galaxy S7 to the iPhone 7, right? After minusing away your cost of materials, your cost to distribute and to put into retail, and of course other costs as well, the value capture based on intangible assets ranges from 34% for Samsung's Galaxy S7 to 42% for iPhone 7 and Huawei. So that's almost half of your value capture just based on intangible assets, because you have very strong patent protection, you have the trademark protection you also have the registered designs and so on and so forth. So imagine that's almost half of whatever value that goes into your product. So that's a very powerful concept. Again, just remember that intangible assets can actually bring a lot of value to your company. So for this chart, I would just like to show a bit about, why is there a need for strong IA? So just recall that we talked about in the previous slides, right? The different kinds of intangible assets and IP that actually is covering a single Nespresso machine. Now, would it be easy for you to replicate the business model? In order for you to do so, you need to think about whether it's easy for you to bypass the whole patent and design registration and so on and so forth. And then how do you actually establish a brand name that can actually fight with Nespresso? So once you have this kind of very strong intangible assets actually protecting your successful product, it is actually a very strong barrier to entry. And this allows your company to price at a premium and to also maintain your lead in the market for much longer time. Okay. Right, so this part I'd like to introduce you to the concept of the innovation life cycle. Because we talked about, what is IP and what is IA, but you cannot let it be stagnant simply because the innovation has to have a life cycle. And the point I want to make is that IP is not just about law or legality issues, right? It is about business and innovation. So if you take a look at OECD's, which is the Organization for Economic Cooperation and Development, their version of the definition of innovation, which I really like. Innovation is about taking ideas to the market. Okay, so again, I repeat, innovation is about bringing ideas to the market. So an idea, no matter how groundbreaking, how creative, how fantastic it is, right? It has to be brought to the market in order for it to have a socio-economic impact. Okay, so if an idea remains with you and is not brought out to the market, then it really loses the purpose over there. So we studied a couple of the most innovative companies and countries around the world. And it seems like there is a common cycle in which the innovation actually happens. So innovation is a continuous cycle of ideas. So you start with ideas at the top, and then you conceptualize and you have your ideation. And that's where you start to produce your IP or intangible assets to be incorporated into your products and services. And then from your products and services, then how do you actually commercialize it? Do you actually sell it by yourself? Do you work with somebody else? Do you go into a joint venture and so on and so forth? There are many different ways of commercialization. And once you actually start selling your products and services, then how do you get back the revenue? And once you get the revenue, you reinvest into new ideas and so on and so forth. So as you can see, this is a continuous cycle and it should not stop, because once you stop, your innovation actually dries up as well. And when your innovation dries up, there is no new intangible assets or IP that actually push forth for your next product cycle. So IP is the vehicle in this cycle where ideas are taken to the market. So when strategically used and effectively used, it enhances your competitive edge, it enhances your growth, and also your success in reaching the marketplace. Now, of course, within each stage as well, you will need to understand that there are also people, so folks that you actually need to work with within and outside of your company. So for example, when you're in the ideation stage, you need to understand and talk to who are your marketing people. When you're in the product development stage, your BD people needs to be involved. When you're commercialization stage, you need to work with your sales and marketing, brokers, and so on and so forth. So along each stage, you will need to work with different people as well. Now, using IP as a vehicle now, think about how this vehicle can keep your innovation cycle going, right? So this innovation cycle, I think it's a very important concept that you need to continually reinvest your monies to keep coming out with new ideas. Okay, so back in 2018, we did a very quick consolidation of audit reports that we actually did for a couple of clients. And we found that for Singapore companies, right, some of the gaps that we have identified is that if you look at the big gray bar, 46% of them actually don't have complete protection of the intangible assets. 25% of them actually don't have a proper IP knowledge, and so on and so forth. But I would say primarily is that you look at this, a lot of Singapore companies actually don't have complete protection of intangible assets. And that's a bit of a worrying sign for us, but we think that can be actually addressed. So just to give you an idea about what the different Singapore companies are actually facing right now. Okay, so you really just need to take care of intangible assets, period. There's nothing else I can emphasize further, but really this point. So the next slide I'm going to share with you is that IP elements in your business planning has got to go step with step with your business planning. So do not think of IP protection as something that you throw to the legal department. It has to go hand in hand together with your various stages of business planning. So if you take a look at the left, right, from your identification of market, likewise, you need to identify what kind of IP assets you have and what kind of IP assets that you need to avoid infringing on as well. Down to market adaptation. So likewise, you need to comply or change your IP rules or change your product and services to comply with the local IP rules and services, and so on and so forth. So you see that every stage of the way for business planning, you also need to put in your IP elements into the planning. Now, your IP strategy can be as minimal as, okay, I just want to make sure I do not infringe on anybody else's IP, and that's fine. Or if you want to, you can go a bit into more defensive, which is you start to register for your IP rights, and you want to make sure that actually nobody infringes on your IP rights. And you can even go offensive, which is you actively look out of people who are infringing on IP rights. So there's no right or wrong to say what kind of IP strategy you want to take and how deep dive you want to be. It really just depends on the nature of business and at which level you want to be. But just make sure that at every stage of a business planning, your IP planning needs to be there at the same time as well. It should not be something that's a standalone. Okay, so just to share with you a couple of typical contracts that you actually find where IP appear so that you know where to look out for them in the future. So non-disclosure agreements, typically when you want to work with a new partner and you're afraid of them divulging certain information you're going to disclose to them, it's always good to sign a non-disclosure agreement. And in there might be IP elements. So employment agreements, so typically if a employer employs somebody, so that means like myself, if I'm actually hired by a company, in the duration of the work, so that means during my course of my work, whatever kind of IP that gets generated typically is then belongs to the company. So that is how most employment agreements are actually structured. So if you don't have that in place, also just keep that in mind to make sure that, you know, it's actually spelled out specifically to say that in the course of employment, the IP generated by your employees actually belong to the employer. And then of course you have agency agreements. If you're working with somebody to actually represent you as an agent to sell your products or services, whether locally or somewhere else, how do they actually handle your IP? Are they allowed to make modifications? Are they allowed to make changes and so on? So franchise agreements, I think that'll be talked about quite a fair bit in the couple of sessions moving forward, so I won't go into that. So manufacturing agreements, I think a lot of times what people may not realize is that your manufacturer may continue to actually producing a particular part that you actually ask them to produce for you, and that's actually illegal. But because they really have the mold and everything, right? So to them, it's like, why can't I just continue doing it? It's actually quite simple, right? So you have to have this actually in place in your manufacturing agreement. And then IT related agreements. So who do you actually outsource your IT to? Do you actually get someone to write specific codes for you and so on? So those are actually need to be in place. And then JVs and trademark or patent license and technology transfers. So those are some of the typical agreements that you'll find that actually IP appears in there. Okay, just going to share with you this very interesting case study that I came across quite recently. And you know, the playwright Oscar Wilde actually says that imitation is the sincerest form of flattery that mediocrity can pay to greatness. So in this case, you know, what has happened is that our beloved Charles & Keith, a local brand, has found something very similar in China, which is the one at the bottom pronounced as Chose and Keach, I think so. Yeah. So it's actually, this Chose and Keach is actually owned by this company called Guangzhou Yuantai Leather. And you look at the storefront, it looks almost identical. And if you visit the website, the look and feel also looks very much like a Charles & Keith website. And incidentally, right, Charles & Keith was actually back in 2014 acquired by LVMH for a princely sum of $30 million. So you need to have your protection in place. And I believe actually even this Chose & Keach, they tried to file for a trademark application in China for this particular brand. So I think in a bit of a silver lining for us is that actually this particular counterfeit was actually caught up by users, because there were some Chinese buyers that actually bought from Charles and Keith, the one below, thinking that it was Charles and Keith, and then they actually posted on social media, and their friends actually called out to them. It's like, hey, that's actually not the Charles and Keith, you know. So there were genuinely buyers that actually got confused and actually bought Charles and Keith, thinking it was actually Charles and Keith. Okay, so this case study is another interesting one. So, you know, the Australia and New Zealand banking group ANZ actually sold off its Asia wealth and retail units to DBS back in 2016. And this was for a sum of 110 million above the book value. Oops, sorry. At the point of time, ANZ had about 5,000 staff, of which about 80% would then join DBS. And with this joining of the staff, right, and this selling of the business, ANZ essentially actually allowed DBS to acquire 1.3 million customers. And out of this 1.3 million customers, right, about 100,000 of them are what we call high net worth individuals with about $23 billion of assets under management. And why did ANZ want to exit this business is because they didn't want to put in the resources that are actually required to, you know, develop the digital and internet banking requirements to fit the different countries. So they decided to sell out DBS, and DBS, you know, in a very short period of time, acquired this 1.3 million customers, and out of which 100,000 of them are high net worth individuals. So you can see, you know, this sale of a business, right? Primarily, a lot of it is about the customer list. So that's a very huge intangible asset that you may not actually see right at the forefront. But this acquisition of customers is actually very important for DBS. Okay, and then another very beloved brand, I suppose that all of you will be very familiar with, Gongcha, and of course Liho. But you may not be familiar with the story behind how Gongcha evolved into Liho in that sense. So maybe I can just give you a bit of the background story. So Rodney Tang actually is the owner of RTG Holdings, right? He first introduced Gongcha to Singapore back in 2009. And in 2016, his franchise agreement actually to operate Gongcha in Singapore expired. He then discovered that Gongcha's parent company, which is Royalty Taiwan, actually then had sold the entire company to Gongcha Korea, which in turn was actually owned by a Japanese private equity. So the new terms were then proposed by the new owner, which were a lot more restrictive. And over the next few months, Rodney managed to actually negotiate a much more favorable terms. But by then, he actually started thinking about, hey, should I still continue to actually license, you know, Gongcha and be a franchisee, or should I actually start to come up with my own new brand? So he decided to shut down Gongcha and introduce Liho, which actually means how are you in Hokkien. And this is a very big shift in the company's business strategy from managing brands as a franchisee to creating and owning one. So this means that he has to use totally different supplies for its tea, use different raw materials, different methods. Even the cup itself actually changed. So the whole logo packaging in the cup itself has actually changed. So the whole process actually cost the company about $1 million. But think about it. You are now creating your own brand. You're no longer a franchisee. So you have actually created out this brand. And how do you actually do it? It's because you have acquired the know-how and the knowledge across the years to say, okay, what kind of tea leaves are best for what kind of concoctions. And he also understood that, you know, for the cup itself, maybe the Gongcha cup wasn't a perfect one. So he came out with this new one with the lid that looks a bit more like a Starbucks kind of a cup. So he found that actually this was actually better for drinking if you need a bit more of the different kinds of ingredients in there. So he made adaptations, and this is actually very powerful because he's actually using his know-how along the way to change his business. So final case study here is actually Hagen. So some of you may be familiar with it. So this is actually a milk bottle brand. So if you look at the milk bottle on the right side, right, it's very different from your traditional milk bottle brands where you actually is round and you need to actually screw it on. So this particular milk bottle from Hagen, actually, when you want to close it, it's just a one snap And then a slight twist, you can actually open it already. And what's very interesting is that the same base is actually used to convert from a feeding bottle into a breast milk storage bottle or into a pump container without having to transfer the contents. So that's something that's actually quite new. And the owner, which is the lady on the left, Ms. Spock, she has a very strong emphasis on IP. And why is that so? It's because into the first year of their initial design, right? And just as she was about to go into the prototyping stage, she realized that the design had been leaked and someone was actually starting to mass produce something almost identical to hers. And she had, at the point of time, haven't actually started registering her designs or filing for patents. So the fortunate thing is that was actually just one of their prototypes, and it's not this square bottle that you see right now. So once they actually started having this square bottle out, right, they made sure that they got their IP protection in place. And they also admitted that the time and cost involved in filing and maintaining and updating IP portfolio can actually cost quite a fair bit. But the thing is, from their experience, without all these kinds of IP protection in place, right, someone can actually come in and replicate your product very easily, and you actually have no recourse or no course of action. So through that experience, Ms. Brock actually realized that you really need to have your IP protection in place in order to ensure that you can actually stave off competitors that comes in. And especially when you're having something like a product which can be easily manufactured, how do you prevent someone else from coming in and actually taking away your market? So because of that experience, Hagen has now been working with different international law firms, and each of them with expertise in patents, design registration, and trademarks, and so on. And they always ensure that the portfolio is up to date. So this was kind of like a happy story because eventually she still managed to actually get a correct IP protection in place for her product. But also it was because of a scare. So I really hope and wish that everyone here can be active in protecting your IP instead of waiting for something to happen and then try to mitigate it. Okay, so the second last slide that I have here is really, so we talked about quite a fair bit about intangible assets and IP. So really, what are the costs associated? Now we know IP protection might not be cheap. So this is really just to give you some context. To file a trademark in Singapore under one mark, one class is approximately $1,000. And that's inclusive of your registration fees. So the fees that you pay to IPOS, and the fees you pay to a professional to actually help you do that filing. Now, then you may be asking, okay, so that's one country. Then can I file for multiple country protection? It's possible. So if you take a look at this thing, which is called the Madrid Protocol, that allows you to file for your trademark in multiple countries at one time. But again, one mark in one class in one country is approximately $1,000. So you need to multiply the cost from there as well. If you talk about a patent in Singapore, one patent will approximately cost you between $10,000 to $20,000, depending on complexity and what kind of technical domain you're in. There's no such thing as what we call an international patent, but the closest to it something is what we call the PCT. So one invention, you can actually help you to start the initiation process to filing into many countries, and that PCT application will cost between 10 to 20K. And finally, for copyright, that's probably the cheapest in that sense. There is this website, if you just Google for WIPO proof, you can actually file for up to 20 articles into a WIPO proof website, and they charge you $30 to get a timestamp. So the timestamp really just to indicate to say, okay, this is your copyright material, and it was actually produced at a particular point of time. So it's to give you the timestamp. Okay, so just to give you a very quick overview about the different kinds of cost. So in summary, I would say strong intangible assets represent a very strong barrier to entry. So this allows your company to actually price your products at a premium and to maintain your lead in the market for a much longer time. So you cannot watch out for what you're not aware. So before launching your product into the market, whether locally or overseas, always carry out what we call a freedom to operate search to understand you're not infringing on somebody else's rights. Protect adequately those that matter to you. So know what your intangible assets are. It's not sufficient. You also need to accord them the necessary protection as well. Use your intangible asset strategy as part of the management decision. So remember again the chart that I showed, right? Your IP strategy cannot be a standalone thing. It needs to work hand in hand with your business strategy. Okay, sorry, this is not the last slide yet. Just to share with you a very quick one, a couple of public resources. So IPOS International has created a series of 15 business guides. So quite a lot of content that I talked about were actually taken from these guides. So anything from rights protection to creation to collaboration to going overseas. If you can, take out your phone, take a quick QR code, or you can actually type into your browser bit.ly/IPOS INTL business guides. Okay, so that's for you to download the business guides. We do have another offering, which is a complimentary intangible IA chat session. So 45-minute session. So if you have any questions or queries about how do you use your intangible assets to grow, what are your intangible assets, how do I commercialize them, if I'm going to a JV with somebody, what do I look out for, and so on. Please, again, scan the QR code or click on the link, and you can arrange for a 45-minute complimentary chat with one of my strategists, and we'll be happy to have a chat with you. Okay, so with that, really, I've come to the end of my presentation. I think we have about 5 minutes left for Q&A. So
yes, we do.
Yeah, back to you, Macy.
Thank you so much, Eric. Okay, we have 2 questions here inside the Q&A box. An anonymous attendee wrote here, if I plan to open a franchise in overseas and I worry about my partner taking my IP, what should I do?
Right. So I think the first important thing is that you need to get your IP registered first. Okay, so those that need to be registered, you need to register them. Those that cannot or don't need to be registered, like copyrights and trade secrets, you just need to have them somewhere in place. And of course, within any kind of franchise agreements, you need to also lay out specifically in there to say what kind of IP you as a franchisor are bringing into this agreement. And sometimes your franchisee may have certain IP that they can actually bring in as well, because they may actually bring in their own knowledge, and they might actually want to improve on certain things that you actually have. So what each parties bring in is what we call the background IP, and whatever that's produced in the future is what we call foreground IP. So whatever that's produced in the future, whether it's going to be a new pattern, a new way of doing things, or a new trademark and so on, who actually owns it? So just make sure that you have these items put in place in an agreement. It's a bit like, when you go into a marriage, you have a prenuptial, right? You just talk about what kind of things each party brings in. And of course, if you have a kid or you own a dog in the future, then who actually owns that in the future as well? So just have these items kind of like actually lay it down. Once you go through these items one by one, you have a much clearer idea about where each party stands. And, it could be a common thing that you're actually looking for. It could be something that's very different. So I think the very open communication is very important. And again, back to the key point, which is get your IP registered first where necessary.
Okay, we have one more question here. This question, okay, it's a little bit, I'm not sure. Let's see how you would interpret it.
Sure.
The IP protection, is it only within Singapore? So I guess this person is probably asking whether is it restricted to Singapore, or if, let's say, if the person were to expand overseas, should they then get IP protection in that overseas market? Over to you.
Okay, so for IP protection, it is what we call jurisdictional in nature, which is if you file for a Singapore patent, it only protects you for whatever that happens within Singapore. Which means that if somebody comes to Singapore, a tourist, for example, sees your product, loves it, and brings it back to, let's say, USA, and then they actually start to manufacture it there, and you don't have a patent protection in US, they can actually continue to do that. So it's very jurisdictional in nature. So having a patent in Singapore doesn't mean that it's protected elsewhere. It's only protected in Singapore. So likewise for trademarks and so on and so forth. But I think for trademark, you have a bit more leeway because we have this thing which is called common law that actually allows you to say, how well known your brand is and so on. But I think that's another side of the remedy. The basis is still that you need to have your IP registered in whichever countries that you're interested to do business in, or to have a production in. So your patents and trademarks and registered designs, make sure you register them in those countries that you actually want to operate in. Yeah.
Okay, we're going to take one last question before we end the session. Eric, I think before we take this, okay, 2 questions came in, but before we take these questions, right, is it okay if you put up your last slide or your second last slide where people can contact you for a 45-minute discussion? I thought that would be helpful.
No problem.
Okay. while you're doing that, so we have a question here from an anonymous attendee again. How do I check whether or not I have infringed on other people's IP?
Okay. So I mentioned this a bit earlier on, which is you do what we call a freedom to operate search. So there are a lot of websites that actually allow you to go into and do a quick search about whether you actually might be infringing on a patent or a trademark or a registered design. Now, of course, it's not as straightforward as what we call a Google search, right? So there are specialized databases that actually professionals use. So the best thing is to actually, have a chat with a lawyer or a patent agent or trademark agent, and they can actually carry out the search for you. So just before you actually launch a product into a new country or within Singapore itself, right? Make sure you don't infringe on anybody's IP by, having a chat with a lawyer. I'm sure they can give you a good quote to say how do you actually proceed to do this kind of searches. Yeah, so work with a professional, I would say.
Okay, thank you. One last question. How do trademarks work for e-commerce?
Okay. So trademarks for e-commerce, I would say then first of all, when you actually establish a brand, and as I mentioned, you can actually file your trademark in multiple countries, right? So in multiple countries, that means using the Madrid Protocol. Where the goods is actually being sold in a particular country, then if somebody actually infringes for your trademark in the particular country, then you need to have that corresponding trademark registered in a particular country. And it comes down to also, again, my earlier point, which is your country of operation. So once you actually have e-commerce operations, you basically actually start going into many, many different countries. And how to actually protect that is, again, back to the basic point. You need to have a registration for the various countries. Again, down to two main things, which is where your goods are being manufactured. So that's one key thing, and where the key markets are. So you can't possibly file for a trademark application in every single country. So just the key focus is on what are your key markets, and really just look at that, because otherwise the costs actually start to escalate quite a fair bit. So you just need to focus your resources on those key markets. Yeah.
Thank you so much, Eric. Okay, your display settings, could you help me swap it to...
Oh, sorry about that.
No problem. Okay, so I think everybody got the QR for this. Could you go one slide back on your business guides?
There you go.
Okay, everybody, this is your chance to take a screenshot or take note of the link to the IPOS business guides. We will also get a copy of the slides from Eric, and we will put it up onto our post-event site. And then if you would like to view this video again, because I think there are a lot of learnings to take away from Eric's presentation, if you'd like to view this video again, you can view it after 20th of November. We will put it up in the on-demand video segment within the virtual exhibition site. So I'd like to take this time to thank Eric for joining us. It is about 48 minutes of discussion over here. I would like to really thank you, because I think there's a lot of learnings over here, and it was a little bit overwhelming for me, but I'm so glad I was here to listen in. Yes. If let's say you have any questions for Eric, you know where to find him. And if anybody else would like to continue to listen on, we've got a next webinar section, which is on F&B trends and franchising, which is by Mr. Albert Kong. Please stay back. It will start at 4:15. With that, I'd like to thank everybody for joining us, and also Eric. Have a great week ahead, and everybody else have a fruitful week ahead. Thank you. Bye-bye.
Thanks, everyone. And thanks, Macy. Thank you.